Okay, we're going to call this meeting to order now. It is 6:04 p.m. on September 28th, 2022, and this is a public training of the Portland Committee on Community Engaged Policing. Before we get into the meat of things tonight, we have a few notes on tonight's meeting or training. So since this is a training that is primarily for the benefit of PCCEP members to be able to function as committee members, we'll be running things a little bit differently than normal compared to our full committee meetings. So the biggest difference is that there will not be a formal public comment period like we have at the end of our full committee meetings. However, we will be keeping the chat open to everybody for the duration of the meeting. So if a question comes up for you, you can feel free to drop it in the chat and we will try to get to it at the end of the training when we have time reserved for member questions. So those are the main differences for how we're going to run things tonight. With that said, we are going to try to respect the main focus of the meeting, which is keeping focus on the information that our presenters are sharing with us tonight. So, we understand questions might come up as we go, but we do have a lot of content to get through because this is a training, a little bit different than, a normal full committee meeting. So, if you can hold on to a question, it might work a little better if we can save it to the end, but, we do understand there might be a little bit of back and forth at points. So, but that's the idea. We're going to try to, get through the content, and then there will be that question and answer period at the end of the meeting. Okay. With that said, we can get started. So I am going to share my screen. Is that okay? All right. Okay, so first I'm going to introduce our presenters for this evening. We have Jared Hagar with us from the Department of Justice, Stephanie Howard from the Mayor's Office, and Sarah Ames from the City Attorney's Office. I'm going to briefly let them introduce themselves at this time. So Jared, do you want to get us started?
Thanks, Dory. Jared Hager, he, him pronouns. I work out of Portland, Oregon for the U.S. Department of Justice. I am on detail to D.C. now, but that's 100% telework. I live in the Park Rose neighborhood. I was born and raised in Gresham, Oregon, Sam Barlow High School, and Lewis and Clark College. I identify as a person with a physical disability, having lost my leg when I was 12 due to a cancer, and also have experienced mental health challenges in my life, including substance abuse and addiction. Yesterday, for those of you who are friends with me on Facebook, was my 13th anniversary of sobriety, and I feel pretty good about that. And I joined the Department of Justice 7+ years ago now, after 10 years of private practice in Seattle. And I did so in order to do civil rights work. And it's been a dream come true. I not only do police reform stuff, I also enforce the Americans with Disabilities Act and other federal civil rights laws. Thanks for having me here to present today.
Thank you for sharing, Jared. Okay, next we have Stephanie from the Mayor's Office.
Good evening, everybody. I'm Stephanie Howard. I use she, her pronouns, and I work in the Mayor's Office as his Director of Community Safety. I am relatively new to Portland. I moved here in February, but I come from Colorado, and my background professionally is that I was a trial lawyer in Colorado for several years in a public defender's office. And so in that role, I represented historically marginalized people and, folks who were just simply unable to afford an attorney. I represented those people in criminal cases as they were accused of crimes and tried many cases. And a lot of that work involves constitutional law, a lot of knowledge around, individual rights and government, the interaction between people and their government. After my time as a trial attorney, I moved into a related field of police oversight. So I worked for the Denver office of the Independent Monitor. And in that role, I was part of an agency that was created to oversee internal affairs investigations for the Denver Police Department and the Denver Sheriff's Office. And so with that kind of background, I came here and was really excited to be able to join the mayor's team and specifically to work with this group and with the work that's being done around the compliance with the settlement agreement and improving the relationships and the work done at PPB.
Great. Thank you, Stephanie. And then lastly, we have Sarah Ames from the City Attorney's Office.
Hi, I'm Sarah Ames and I use she, her pronouns. And I, my parents moved me to Portland in 1977. And I won't even tell you how old I am, except I did graduate from high school right here, walking distance from my home and from downtown. And I returned after college and worked in a number of public affairs and communications jobs in local government and state government, various things. And then I went to law school at the ripe old age and practiced in labor and employment law for private practice here, but really had a yearning to get back to doing work that mattered more to the community as a whole and to the city that I love. And this position came open, and it's been almost closing in on a year that I've been working for the city attorney's office, helping the city to get into compliance with the Department of Justice settlement agreement and pursue constitutional policing reform. So I'm very happy to be here.
All right, thank you, everybody. Okay, next up, we will be, so I will give a little overview of what this training will look like. So, tonight we're not only going to be talking about the history of the settlement agreement and how it relates to PCCEP and kind of the iterations that PCCEP has been through. But we're also going to try to bring that to the present day and talk about how, the history relates to you all now, and kind of what our work looks like today, the things that PCCEP, has to do throughout the course of our work under the settlement, under the PCCEP plan. So we're going to just take a look at how all of those things work together, all of the different moving pieces. And all three of our presenters are going to walk us through different parts of the training tonight. So we are going to get started with the history of the case and the settlement. And I believe Stephanie is going to start us off.
Thank you. Yeah, so as Dory mentioned, we want to be able to give context for the work that you're doing now. And so we've been working together to figure out how to do that in a way that is both complete, but also efficient and focusing on the things that most impact you today. So I'm going to start by talking a little bit about how this case began and how we, came to be here today. Now, as I'm sure many of you know personally, and for those who don't, who I'm sure you can imagine, we could spend hours and hours and hours talking about the detailed history of how all of this began. But we're not going to do that because we want to focus on the parts that are the most relevant to the work of PCCEP and try to make sure that we can answer your questions. So from a high level, I'm going to run through that and just talk a little bit about how we got here. As many folks, probably all the folks on this call know, there was a history in Portland of incidents of force by police that had led to some pretty tragic deaths. And many of these incidents appeared to have a nexus to a person experiencing mental health or being in crisis around that. But the real turning point as it relates to the settlement agreement came in January of 2010. And that was when Aaron Campbell, who was an unarmed African-American man experiencing a mental health crisis, was killed in an officer-involved shooting. That incident really was a tipping point for the need to make changes and to address deficiencies that were ongoing with policing and with how our community and our government was dealing with people, particularly people with mental illness and those who were, having incredibly negative experiences with law enforcement. So in the wake of Aaron Campbell's death in February, so just a month later, then Mayor Sam Adams and then Police Commissioner Dan Saltzman had been working closely with leaders in the African-American community because they were trying to find a response to this horrible incident that was meaningful and would beget positive change. And so what happened was that Mayor Adams and Commissioner Saltzman wrote a letter to the Department of Justice requesting an investigation. And there's a little more to that. They wrote a letter to Senator Wyden and Congressman Blumenauer asking for that DOJ investigation. And the senator and congressman then forwarded that to Attorney General at the time, Eric Holder. So that letter was sent in February 2010, 1 month after Aaron Campbell's death. In June of 2011, so about a year and a half later, the DOJ Civil Rights Division began the investigation that the city invited them to do. And obviously, because that investigation was requested by the city as a whole and the PPB fully cooperated with the investigation, and they were eager to find ways to help PPB improve. The investigation was very expansive and very detailed, and it lasted well over a year. And ultimately, in September of 2012, the DOJ sent a letter to the mayor with its findings from the investigation. And I'll focus on the key findings for that because I think they're the most relevant to what we're going to talk about tonight. But the key findings, according to the DOJ, were that while most of the uses of force that were reviewed by DOJ were found to be constitutional, there was cause to believe that the police bureau had a pattern or practice of using unconstitutional excessive force against people who had or were perceived to have mental illness. And this degree of force, this unconstitutional force, was found to be in violation of the Fourth Amendment. Jared will talk more about that shortly, but that Fourth Amendment provides all of us the right to be free from unreasonable searches and seizures by the government. And so specifically, when an officer takes a person into custody under certain circumstances, that is considered a seizure for constitutional purposes. And again, Jared will go into that a bit more in a few minutes. Based on these findings, the pattern was believed to be the result of deficiencies in policy, training, and supervision and accountability in the police bureau. And so based on those findings, the city and the DOJ entered into negotiations to reach an agreement. And so we had the findings in September, and by November, there was a settlement agreement that had been reached by the city and DOJ to address those findings and find the best ways to improve and strengthen the practices of the PPB to create a more constitutional police force. In December, the city council approved that settlement agreement. And so, and again, I'm sorry, I'm talking about December 2012. And so shortly thereafter, the agreement was filed with the US District Court. And that's when Judge Simon came into the picture. So the parties, the city and the DOJ agreed to file it with the court. And there were a few reasons for that, but among them was that by filing this with the court, they would get the court's approval of the terms of the settlement agreement to ensure that it was adequately addressing the concerns of the DOJ. And it also offered the authority to ensure that the agreement would be enforced. It gave the court the ability to make sure that everyone who was a party to that agreement was meeting their obligations under that agreement. And so I think I'm going to pause there because there are some in-between sections, but that's the very broad overview of how the settlement agreement came to be. And Jared's going to speak a little bit about the scope of the settlement agreement. And then I think with that context, we can talk a little bit more about who is who in the settlement agreement today. So I'll hand it over to Jared.
Thanks, Stephanie. I now, in part of my detail, I serve on the committee, Case Selection Advisory Committee, that takes referrals from all over the country to open up new cases. And I appreciate what Stephanie said about the mayor and the police commissioner calling for DOJ involvement. I did just want to answer Barbara Baczynski's question in the chat. You know, the amici, the AMAC had also been calling for the Department of Justice to investigate the Portland Police Bureau. We had a number of referrals that all go into a decision process that goes up to the political appointees on whether or not a case is actually open. So there was a lot of sources, and I understand that the AMAC and the MHA will be providing their own training. This is for the lawyers in the city, the parties, to provide a training. The scope of the settlement agreement, I got 10 minutes, so I'm going to try to be real quick here. You know, the findings letter did find a pattern and practice of unconstitutional force against people in a mental health crisis or perceived to have mental illness. But that really is just a hook. The law provides that wherever the Attorney General has reasonable cause to believe that any governmental authority is engaged in a pattern or practice of conduct by law enforcement that deprives people of constitutional rights or statutory rights. So the Americans with Disabilities Act sometimes is a hook for us to initiate this type of action. Then the Attorney General can initiate a civil lawsuit to obtain equitable and injunctive relief. That means we don't go after damages. We're not trying to put people in jail. Equitable and injunctive relief means that we can get a remedy that forces change, that requires a local government like the city of Portland to change things in order to address the unconstitutional practice. But once we have that hook that allows us to initiate a case, we can either litigate it or we can resolve it through a consent decree / settlement agreement. And in this case, the parties resolved it. And so while the findings letter, I think, is important context from 2012, once the settlement agreement was adopted and enforced, and that didn't happen until 2014, that really becomes the guiding principle. That is an enforceable law in a sense, because it's an order of a federal court that now governs our proceeding. And so, you know, even though mental health was the hook, really, I think the scope of the settlement agreement is broader than that, because this is a Fourth Amendment case about unconstitutional force. If you look at Section 3 of the agreement, that deals with force. If you look at Section 4, it deals with training. Section 7 and 8 deal with accountability mechanisms, and Section 9 deals with community engagement. Those are general remedies that apply to all aspects of the Portland Police Bureau and the city of Portland. They are not limited by encounters with mental health. They are not limited by simply, you know, a certain type of use of force. It's very broad. There are 2 sections that deal specifically with mental health, and we established remedies with the city's agreement to stand up a behavioral health unit, an advisory committee, specially trained crisis intervention officers. There are special crisis intervention training. There are provisions in Section 6 for crisis intervention dealing with 911. That's the Bureau of Emergency Communications, that they know how to allocate calls to. They go to police, whether it should go to a ECIT, that's the Enhanced Crisis Intervention Trained Officer, or whether it goes to a general patrol officer who has 40 hours of regular crisis intervention training. And 911 can also send it to, you know, non-governmental agents or alternative response models, such as Used to be called the Multnomah County Crisis Line. Now it's the Behavioral Health Call Center. I think it's the BHCC. So those remedies are specific. The rest of them are very broad. I think that's important for you to understand so that you know that when we talk about the community engagement provision, section 9 deals with you all, the creation of PCCEP. They aren't limited to mental health or any specific type of encounter. They are quite broad. And when we think about community engagement strategies from the Portland Police Bureau, their community engagement plan wants to reach out to all different communities of Portland to establish that relationship. That's the best way to build trust. So while there are specific provisions of the settlement agreement dealing with mental health, most of the provisions are quite broad. All of the provisions have to be implemented. Paragraph 153 requires implementation. And so, for example, section 3 has requirements to, say have a force policy that complies with best practices, has certain requirements to de-escalate and give warnings and try to avoid or minimize force. But just adopting that policy wouldn't be enough. The Bureau has to implement it. That's paragraph 153. And what implement means is it has to, if it's a policy, it has to be developed and put into place. And then, the key, and this is in paragraph 33, the definition of implement, it has to be consistently and verifiably performed over time. So in actual practice, and through the use of regular audit tools, the Bureau and the city have to show that they have implemented those policies. The case has, the settlement agreement has specific termination provisions, and the case will end when the city is in substantial compliance with all provisions of the settlement agreement and maintains that compliance for 1 year. That's paragraph 175. Substantial compliance is defined, and it's defined as being achieved when any violations of the agreement are, quote, minor or occasional and are not systemic. So who decides? Who decides when the city's in substantial compliance? Well, the settlement agreement provides that the Department of Justice is the arbiter of substantial compliance. That has caused a little bit of angst at times, and it is an unusual position in this case for the Department of Justice to both represent the plaintiff, United States, and be the monitor of compliance. In most of our cases, all of our cases across the country for police, some variation in the prison context, we have an outside entity, an independent monitor, who is a court agent who does that work with a team of experts. And here we both decide whether there's substantial compliance, and we're also tasked with enforcing the lack of substantial compliance, which can present a little bit of an issue. I know it's been an issue with some community members in the past, and I think it's been an issue with the city in the past. But we don't decide in a vacuum, so to speak. We rely on other opinions, including the compliance officer, community liaison. I believe Dr. Rosenbaum and some of his team might be here. The Portland Police Bureau also does its evaluation. Every quarter, they produce a report showing what they've done to comply with each of the provisions. And we rely on their self-assessment as well. And in fact, in many jurisdictions, there's a provision to transition monitoring to the city so that the city can stand up on its own. And when we leave, when the case ends, there can be some community trust in the fact that compliance is going to continue. The third entity that really is supposed to help us with our opinion is PCCEP. And so like COAB before PCCEP, and we'll talk a little bit about the evolution to PCCEP, you all have a standing authority to independently assess the implementation of this agreement. And the court does, I think, expect to hear from you all on what you think about implementation, whether it's going good or poorly, or whether there are some things that could be better. And I don't think that's just limited to criticizing the Bureau or the city. I think, part of the implementation of the settlement agreement is how the Department of Justice is doing. So I think we're fair game to criticize if you think we're doing something poorly, or, ideally, if people are doing something well, you give them kudos for doing something well. So that is a real brief overview. I've given trainings in the past about each specific section of the settlement agreement, and there are 7 substantive sections now. And I'm happy to do that at any time in private or in another meeting. And I think the city attorney has done that. I believe it's up on YouTube when me and Tracy Reeve, a prior city attorney, went through each section. It is a little bit dense, so I think that, it can be tricky to get a grasp on, but that's why sometimes the dialogue helps. So I know Sarah and myself would always be available to you all to help talk about specific provisions. And you all get quarterly updates from the compliance officer too, and they go section by section. So you are not alone. Lots of people here to help you through the way, but hopefully that gives you a little bit of an overview of the scope of the settlement agreement. And with that, I think I pass it back to Stephanie, or maybe to Sarah.
I think it's me, Dory.
Yep,
Okay.
it is you, and let me pull that back up for you.
It's okay with me if you don't. I just want to make sure I'm in the right spot, but
You are, yeah.
great, perfect. So yeah, so Zainab was asking terrific questions in the chat, and I think this is the section where we can answer some of that. So there are lots of different groups involved with the settlement agreement today. And so I can speak a little bit to what how those groups relate and what their roles are in this agreement now. So the Department of Justice, that's Jared and Jonas Geisler. And I don't know if Jonas is on tonight, but I know he's on several times and he's always in court. So they represent, as Jared said, they are the plaintiffs in the case representing the Department of Justice. And also currently they are the monitors of the settlement agreement. So, and I'm not sure, Jared, maybe if that's just your role or if that's both of you, forgive me if I'm not sure. At any rate, the DOJ, that's probably the clearest one to identify in this whole landscape. So probably the one that people have the fewest questions about. Then as another party to the case, the defendant is the city of Portland. So the city as a whole obviously would include the police bureau. And the city is represented in the case by the city attorney's office. And so as many of you have seen in court, Robert Taylor, Heidi Brown, Vamshi Reddy, and Sarah Ames are all attending and representing the city as a whole in that court proceeding. Sarah is going to speak a little bit more as to her unique role in that and with relation to PCCEP. So I'm going to let her handle that and just move on to the next section, which is, I'm sorry, I'm not following Dory's slide. So mayor's office. Obviously, the mayor is the mayor. He is, the figurehead of the city. And so his role is to represent the city and to obviously, contribute in any way to figure out how to get us in compliance, what needs to happen, and to ensure that the city is doing all it can to meet the terms of the settlement agreement. And so as his director of community safety, I'm the mayor's representative in these meetings and, in different settings where we have topical discussions about the settlement agreement or the city's compliance. I represent the mayor, and so I am generally the person that is going between the mayor and other parties here, but particularly for PCCEP, I'm your contact for the mayor's office. And so I am always available to you if there's anything that I can do to help. The mayor, as we'll talk about more, also has a special role in the appointment of PCCEP members. And again, we can talk a little bit more about that in a bit. I mentioned the city attorney's office already. And so the next group here, we have PPA. Now, given the significant interest in the settlement agreement, there are other stakeholders who sought permission to become parties to the case. So the DOJ is a party and the city is a party. And as soon as the case was filed, there were 2 groups that immediately requested to also be parties to the case. And the Portland Police Association was one of those parties. They requested to be a party, and Judge Simon recognized that they had an interest and he granted their request in part. So what you will see is that the PPA, Portland Police Association, is a defendant intervener. So they are also a defendant, but by the means of intervention. So they are, would be considered a party to the case. The Albina Ministerial Alliance also immediately filed a request with the judge to become a party to the case along with the city and the DOJ. And after considering their request, Judge Simon did not make them a party, but he recognized AMA's unique interest in the case and made them what's called enhanced amici, because Judge Simon wanted to make sure that they had a seat at the table. And amici is a term, legal term. I think somebody mentioned this in the chat and answered that well. But just to put a finer point on it, in a legal context, if there is a lawsuit and we have groups that have perhaps some unique perspectives or some expertise that can help a court in figuring out or deciding important issues, but they may not have interests that are quite the same as the people who are the parties, that would those parties, those groups can be brought into a case as an amici or an amicus. And that means a friend of the court. And that status grants those groups the ability to file briefs in the case. It gives them the ability to be heard at court hearings and to provide information and share their positions about the case. So I think we're all very accustomed to this case and Judge Simon providing lots of opportunity for public feedback, but it's just a step above that where we have the direct ability to share their specific expertise and interest directly with the court.
And Stephanie, could you briefly, for members who don't know these two amici, could you briefly let us know why they were added?
So the Albina Ministerial Alliance, the AMA, were directly involved in the request to bring the DOJ in for investigation. That group had a long history of concerns about policing in Portland, and those folks, I couldn't speak to the history of the organization, but as a group, they were focused on creating police reform in our community. And so they had a history of doing that, and obviously had a place in this conversation directly because of their work and because of their experience in Portland. The Police Association is that's the police union, and the judge, found their interest to be in relation to the remedies that were developed through the settlement agreement, because they represent the actual police officers who would have to comply with the remedies and who would be subject to the remedies that were being imposed by the settlement agreement. Does that help?
Yes, thank you.
Okay. A bit later, not until 2018, the Mental Health Alliance, the MHA, requested also to become enhanced amici. So they were requesting the same status as the Albina Ministerial Alliance. And the judge did not grant them exactly the same status, but he did recognize that MHA would be able to provide subject matter expertise around issues related to mental health. So he granted them status as amicus. So we have enhanced amicus or amici in the AMA, and then we have amicus or amici, I guess is the plural of that. And so the MHA is also considered a friend of the court, able to submit briefs, able to provide a position on any aspects of the settlement agreement, and able to share their expertise in relevant areas. That brings us to the COCL. And so the settlement agreement created an independent entity to provide compliance reporting, collect data and community input related to the settlement agreement. And they had some other unique roles, which I think Jared is probably going to speak to in a moment. But in that creation, that was the compliance officer and community liaison, so the COCL, COCL. And later the city contracted with Dr. Dennis Rosenbaum, who's on the call and probably can add a little bit to this to flesh this out more than I am. But Dr. Rosenbaum is the COCL. He and his group generate the compliance reports that you all see. I think those are done quarterly, and they're responsible also with responsible for collecting community input on those compliance reports. I think this is a good transition, Jared, to you. If we could talk about, this is a really simplified version of the COCL, but perhaps this is a good transition to talk about the creation of PCCEP and sort of the interplay with the COCL and how we have evolved to the PCCEP we know today.
Thanks, Stephanie. And I see that I've got 5 minutes for this. I hit my last time on the nose. This one will be tougher.
That might have been an oversight on my part, Jared, or a mistake, actually, just straightforward.
No, it's fine. I appreciate leaving more time for questions. So I do want to quickly run over some of the differences between the COAB and PCCEP. Just know that Section 9, as it was written in the settlement agreement, originally required the creation of something called the Community Oversight Advisory Board, the COAB. It ended up not being a successful framework for community engagement for a number of reasons. I think the most obvious or impactful was that members rotated off or quit, and there was a very cumbersome appointment process that was never really hewed to or followed or engaged in. And so the city, the community board really just became unable to work. There were quorum issues. I think at the end, there were only 4 members of the original, there might've been 15 members, and there were 5 police non-voting liaisons that also sat on that board. So the parties got together in 2016, 2017, and devised amendments to the agreement that would substitute PCCEP and some of the PCCEP for the COAB. And some of the key differences, they're identified in the ordinance, and the ordinance I know is linked in your reference materials, and it's worthwhile to look at that. But I want to highlight a few that were especially important to our getting approval of the PCCEP changes. First was that COAB was solely a creature of the settlement agreement. When the city achieved and maintained substantial compliance, the settlement agreement would go away, the COAB would go away. PCCEP, by contrast, is created as a requirement of the settlement agreement, but is created by a city ordinance so that it can outlive the life of the settlement agreement. And that is by design. There were some concern with some folks that there were perverse incentives for the COAB not to achieve substantial compliance so that federal oversight might maintain in the city. In particular, the COAB was required to craft a community engagement plan for the Portland Police Bureau, and they never really got that finished. They got sidetracked by a lot of other things they were interested in. Relatedly, all the COAB provisions were contained in the settlement agreement, and that made for some inflexibility. Changes would have required a formal amendment, a fairness hearing, a court determination that the changes were fair, adequate, and reasonable. And by contrast, with the PCCEP, the plan lives outside of the settlement agreement, so it can be changed relatively more easily. But in order to safeguard the protections of what existed for the COAB, the city has to consult with the amici and consult with the union and get the Department of Justice's approval of those changes before they'll go into effect. And so, you know, taking the role of the court, that's how I see the Department of Justice's approval authority. We assess the adequacy of the changes. And right now, I know we've been proposed some changes. We have some concern over the adequacy or inadequacy because of the quorum issues and what happened between 2021 and 2022 with PCCEP and its membership, and, you know, reflecting what happened with COAB back in 2015. Another important difference is that COAB was chaired and facilitated by the COCL. Here, now with PCCEP, it decides its own chair, its own facilitator, it sets its own agenda. And that is a crucial difference with PCEP as opposed to COAB. And that self-determination, again, was by design, and you can read about that in the ordinance. Another important change is that COAB had that complex appointment and replacement process. That made it really difficult to get all the people in the room together when someone rotated off in order to get that person or that chair filled again. PCEP, by contrast, puts the sole appointment replacement power within the mayor's office, a single entity that doesn't have to consult with every neighborhood district, with all of these other interested parties and groups. And so that there can be some command and control and streamlining. And again, that was by design, given the quorum issues that happened with COAB. And unfortunately, we had those same issues repeat themselves between October and really, I think, June. I think we started getting the membership back together for PCEP. A final one I want to mention, I got 10 seconds. COAB was subject to the public meeting laws. It had to conduct all its work in public. PCEP is not. It is a mayoral committee, and you can read that in the ordinance as well. It is not subject to the public meetings law. You can choose to subject yourself to the public meetings law, but it isn't necessarily so. And so again, those changes are all within the ordinance. Am I also supposed to talk about the content areas? Because I totally blew my 5 minutes if that's the case.
Yeah,
am,
you,
Dory.
you have, I put more time on that point. So you can, there, I think I just, yeah, so you can,
Okay.
you can split up this time however you want.
I'm going to take 5 more minutes to talk about the content areas under the settlement agreement and the PCEP plan, because really this is almost exactly the same as the COAB. And so we wanted to maintain these essential content areas, and I've identified 3. And the first really should be, it says implementation of the settlement agreement. It's really this independent assessment of the implementation of the settlement agreement. This language was quite important to the AMAC. It comes from the COAB, that's old paragraph 141, and it's been replicated in the PCEP plan again at the request of the AMAC. And I know Judge Simon has mentioned this authority as being especially important to the court. And when we look at one of the court's orders, we think that the court expects you, some might say is ordered. I don't think the court's ordering PCEP to do anything. He's not going to throw you in jail if you don't come talk to him. But there is an expectation, just like COAB, that PCEP will appear at status conferences and talk to the court about what your view is of the implementation of the settlement agreement based on your conversations with the community, based on your hearing quarterly town halls with the COCL, based on hearing from the Department of Justice and our roughly annual compliance assessment reports, based on your many conversations with the city and the Portland Police Bureau. And I do want to give credit to the Portland Police Bureau. They've been very supportive of PCEP. They show up to a lot of the meetings, if not all of them. I know Mary Claire Buckley is a trooper. She's the Inspector General. Now, the one thing I want to mention about this task about assessing implementation of the settlement agreement, there's a lot of ways you can do it. You can do it through a statement. You can do it through individual statements. You could do it, through something in writing or some, oral testimony. A lot of ways to do it, but it's very hard to do at the last minute. And so it's something to consider having a specific issue focused subcommittee on. And I know you've had one in the past. To be thinking about this, because it's a fairly regular occurrence that we're going to have status conferences. And I believe the expectation, if not the requirement, is for PCEP to share with the court its view and the community's view of how it's going. How is the implementation process going? The second main content area under the settlement and the PCEP plan are PPB policy recommendations. Now, the Portland Police Bureau has a slew of policies. Some are directly related to the settlement agreement. Some have no relation whatsoever to the settlement agreement. But I want to also give credit to the Portland Police Bureau's policymaking process. They have a regular schedule and give a consistent opportunity for public input. And this is an obvious source, I think, for PCEP to make recommendations on the policies that are implicated in the settlement agreement or that are implicated in community concerns about policing. And so I would encourage you to think about an issue specific subcommittee for this purpose, because it is a lot of work, and the COAB had its own policymaking process. Now, I do suggest that you all need some training on how to comment on policy. There is a specific type of art to it. You have to understand what the policy does and doesn't do. You really ought to speak to the subject matter experts to understand that. Speak with community members to understand their concerns. Consider changes means make a red line of the policy with the changes that you would like to see and the community would like to see. And a subcommittee really makes it most sense in my mind for how to go about doing that work. Now, Ashley Lancaster is part of the Portland Police Bureau policy team. She has been very open and willing to come speak to PCCEP about policies and what they do. Mary Claire Buckley is the Inspector General, again, sits above that. And again, it's a regular open process. Portland really is the gold standard, I think, in terms of community engagement with its policy-making process. Many major cities across the country, you'll be lucky to see their policies posted online, let alone to encourage and welcome input into the policy like the Portland Police Bureau does. So I would encourage you to take advantage of that. That really is a core area. I'm at 10 minutes, but let me get to the last one because this is an important one. It was a specific requirement for the COAB to help craft Portland Police Bureau's community engagement plan. So it's not just community engagement, although that's important for you all to meet with the community. I think the city and city staff can help you with that sort of community organizing. But in terms of the Portland Police Bureau's community engagement plan, that is a specific reference, specific requirement that was part of the COAB, and it's preserved in the PCCEP. That's paragraph 142, paragraph 146, paragraph 145 also talks about it. Portland Police Bureau has to work with PCCEP to improve its engagement with the community. How does it do that? Well, it has a plan that you all helped create. I don't know if there's any existing members from when that was created in 2019, 2018. It's a 5-year plan. It's subject to revision and check-ins. We have all agreed on metrics on how to evaluate community engagement. That was a requirement of paragraph 149. We can provide those to you if you don't have them. So again, I might suggest a training on how to make recommendations to the police bureau. How does that, well, who do you need to talk to? What do you need to think about? What community members do you want to talk to? What should it look like? What should it say? What sources of evidence should you have to support your recommendation? All of that might be for another time. But again, and the last pitch I'll make is a subcommittee devoted to this issue of the community engagement plan might make sense. I know in the past you all have organized around identities. There's been a racial equity subcommittee. There's been a behavioral health or a subcommittee for people with mental illness. You know, I think there's no one right way to do it. And you should consult with the community before you make any decision on how to organize yourself into subcommittees. The only wrong answer would be no subcommittees. I think that's the wrong answer. You have to have a way you can do the work in these meetings. The big full meetings aren't really possible. I think if you had issue-focused subcommittees, then you wouldn't have people siloed, racial equity interested folks here and behavioral health or mental illness focused people here. They would come together and you would be talking about community engagement strategies or policy recommendations or use of force subcommittee. I mean, you could do a lot of different issue focused things. I just throw that out there, something to consider. Again, there's no one right way to do it. There's a lot of pros and cons, something for you all to consider. So I definitely blew by my time there. That is 12 minutes. So with that, I will pass it on and look forward to questions that you all may have.
You're good on time, Jared. All right. Next up, we have Stephanie. Yep, Stephanie, you're up.
Great, thank you.
Oh,
yeah. Oh, okay. So, with all of that information, one big question is, how does PCCEP fit into this framework of police reform, right? And how does the city support PCCEP in doing that work? As many of you know, the logistics of achieving the work that PCCEP has to do has been a challenge, and a challenge the city, is committed to doing better on. The city really has let PCCEP down from time to time, and I fully acknowledge that. I think that's been acknowledged many times, but As I'm, I won't harp on it, but again, I'm really happy that we have Dory here and that, the city's really taken a strong approach to how we support PCCEP and our other committees that are focused on police issues. As you should, I think most of you have heard, and some of our new members may not yet be aware, the city has dedicated a unit of staff specifically to help support our community advisory groups in achieving their individual missions. And it's a little bit awkward because here we are, the city is a partner to this settlement agreement. And so that can get a little bit confusing, but to try to clear that up, this unit of dedicated folks has been seated in the Community Safety Division. So that group works separate from police, separate from the mayor's office, although closely with us because we're responsible for the functionality of this group. The Community Safety Division staff, where Dory works and where some of our other support staff work, is designed to help make sure that PCCEP and other groups have dedicated support who can help them achieve their missions. So what does that mean? Staff, as we all know, these issues and issues with public meetings laws, the technical issues around the settlement agreement and all of the parties involved here, these are really technical and kind of complicated issues. And so the goal here is to provide you a staff that has some expertise in how to navigate that and can provide you with guidance on how to function in that framework, and also to help try to provide guidance on how other techniques that might help, or other strategies that might help you to be successful in completing your mission. And the biggest role here is to take work off of your plates that is not the work that you have volunteered here to do. So the administrative work, the coordinating types of work, as much as possible that the city can take from, away from you, so that you all can focus on the substance of this work, and you can focus on, making sure that the issues that, are important to you are the issues that are addressed, and the the ability to communicate those issues and engage with the community is being achieved. With all of that said, I want to make sure that this group knows that, if for this group, it's Dory. Dory is here to be a resource to you. Dory is here not to dictate, not to do anything that is trying to control what PCCEP does, but Dory has been asked by all of us to support you by making suggestions, to support you by making proposals for you to say, yeah, no, that works, that may not work. But all of that is with the idea and the goal of trying to make your life about the substantive work and not about the logistical work. So I want to make sure that it's clear that as we try to help and build new processes that can lead to greater success for PCCEP, that's the context that everyone knows. That's where that is coming from. It's not coming from a place of control or trying to lead anyone by the nose. It's coming from a place of trying to be supportive and trying to offer options for the group to decide what makes the most sense, and really just to try and help accomplish the goals that the group and that PCCEP has. And I'll say just one other thing as we're talking about how PCCEP fits into the framework. As I think lots of I know we have some members of other subcommittees, or not subcommittees, other community groups here tonight. The Portland Police Bureau has a large number of different community groups that serve different roles and offer different areas of input and engagement. So I'm going to run through a couple of those so that PCCEP can understand where certain responsibilities and obligations are also being tackled by other community groups, and where there might be some great opportunities for collaboration with those groups and coordination, so that nobody's reinventing the wheel. So for example, we have the Citizen Review Committee, CRC, and that is a community group that is tasked primarily with focusing on police accountability and playing a role in the discipline system as it exists right now. So they have a very specific and technical job in that. And I'm sure many of you are familiar with them. And I think, what I'd really like to do is to see us bringing some of these groups together with all of you. And I think they can describe what they do very well. But I think of CRC as the accountability and disciplinary group of community members focused there. We also have the Police Accountability Commission. And that, as many of you know, is the group of community members that was brought together by City Council to design a new accountability system for police. So that group is working diligently to bring that idea together. And so that's one of their, that's their big task. I'm sure people have heard of the FITCOG also. And FITCOG stands for Focused Intervention Team Community Oversight Group. The FITCOG is a group of community members that has been tasked with overseeing the police bureau's focused intervention team. And that is a group of officers specializing in gun violence. So those folks are focused in that lane, specifically on in terms of police oversight. The PPB also has a wide variety of other community groups, and I'm just going to run through these really quickly, but there is a greater coalition of advisory groups that consists of members from the African American Advisory Council, the Alliance for Safer Communities, the Asian Pacific Islander American Council, the Behavioral Health Unit Advisory Council, the Latino Advisory Council, the Muslim Advisory Council, the Slavic Advisory Council, and the Training Advisory Council. And I know Nathan Castle, for example, is a member of that, and they're focused specifically on reviewing training materials and helping PPB develop training that meets the community standards and reflects the values of the community. There's also the Police Equity Advisory Council and the Police Bureau-wide Advisory Council. And so I'm not going to go through all of the purposes there because we don't have time for that. But my point here is really that there's a lot of overlap with many of the work that these groups are doing. And we want to make sure that the city is doing a good job of trying to help these groups support each other and again be collaborative when there is that overlap, so that we can learn from each other's expertise and focus on specific areas and share perspectives based on these kinds of perspectives, and really to avoid duplicating efforts unnecessarily. And so I'll stop there because I'm sure I'm out of time. But I can certainly answer more questions, and I think there are lots of other things that we could share, but I hope that that can be the subject of some future meetings, as well as how to collaborate among those groups.
Excellent. Thank you, Stephanie. Okay, and then I think this is getting us to the end of what we have laid out. So Sarah Ames from the City Attorney's Office is going to walk PCCEP through what PCCEP is sort of obligated to do, as well as some of our other rights and responsibilities that are laid out by some of our governing documents. So I'll hand that over to Sarah.
Hi, thanks a lot. I did, as I went through the, this was a good opportunity for me to review the settlement agreement and the PCCEP provisions in that, and this PCCEP plan. And I kind of highlighted, I loved Jared's focus on the 3 different content areas. So I'm going to talk about some of the responsibilities there. And I would just say that Jared's characterization is absolutely right. That the court and the PCCEP plan even doesn't do too much ordering of exactly what you have to do, but it authorizes a whole lot of different activities that fall into those 3 buckets, and gives you the opportunity to shape the course and to set your agenda and really fulfill a unique role among that whole alphabet soup of different police advisory groups. You really have a certain power, and I'll go through some of that. First, I did want to say that if you look at the settlement agreement, the city as a whole, big picture city, was the one who was sued in this and entered into the settlement agreement. We are the party to the settlement agreement, and rightfully so. We are the ones that have a direct and pressing obligation under the settlement agreement more than PCEP as an institution. So, for example, paragraph 144 says that the city has to provide administrative support so PCEP can perform your duties and responsibilities. And the city has to provide PCEP members with appropriate training and on specific things necessary to comply with requirements of city and state law and to comply with the settlement agreement, honestly. And so we have a bunch, the other major obligation of the city is to provide thorough and timely responses to PCEP recommendations and requests for information, and that we should endeavor to do that within 60 days. That is a very powerful tool for all of you in this work as you approach this work, and it's somewhat unique from the other areas. So there's a lot of obligations on the city. PCEP's responsibilities in the settlement agreement are not as spelled out and dictated as Jared mentioned. Paragraph 151 says, PCEP shall meet as needed to accomplish their objectives as set forth in the PCEP plan. You have to hold regular town hall meetings that should be open to the public. You do that. And hold monthly meetings with meaningful opportunity for public comment before conclusion of deliberations and voting. And it says that a responsibility of PCEP is to form subcommittees that may meet at other times during the month. So there's a whole lot of flexibility in how you approach the work, what your priorities are. It allows for you to hear from the public and shift priorities, focus on these different content areas, and really kind of with the support of the city, which, as Stephanie said, has been somewhat lacking recently, and we're hopefully, building the framework to support you in doing the real substantive work now. And that substantive work, as Jared said, is, the independent assessment of implementation of the settlement agreement. And that includes, the plan goals in the PCEP plan. And I color coded this, and it looks rather a mess. The goals say that PCEP members will independently assess the settlement agreement using the tools outlined in this plan. And some of the tools outlined in the plan are that you get the demographic data regarding the subjects of police encounters, like some of the stops information that you reviewed last week, so that you can assess whether there is, some of the trends, and you can question the PPB directly about what some of the trends are and what they're doing to address trends and in the demographics of people who are stopped, for example. The PCEP, this is one where it is a little bit more directive. The PCEP shall coordinate with the COCL to host the open town hall meetings. Those COCL reports are an outstanding opportunity for you to look at their assessment of every single paragraph, whichever ones you're most interested in, and to focus on whether you think their assessment is on target, what the community thinks of it, whether there are other areas that might be pushed more. And that is one real tool in the plan for you to offer your independent assessment and community-based assessment of what is going on and whether the city's complying with the settlement agreement terms. And then also under this, as Jared mentioned, the plan, the PCEP plan, which you all have a copy of, the existing PCEP plan, lays out some of the obligations or responsibilities of PCEP in 3 different places. It has goals, which have a big picture view. Then there is a whole list of the scope of work. And it's interesting because it says specifically PCEP will be authorized to. And that, to lawyers, you look at the difference between the word you shall do this, you're authorized to do this. That really vests a lot of power in PCEP to take on these tasks. It doesn't say you have to do exactly this, but it gives you the power to do it. And one of those things is to appear before the court at the status conferences. The so that's kind of the first big bucket of work, the content area of the that Jared pointed out, the independent assessment of the implementation of the settlement agreement. The second major one, as he discussed at some length, is the policies. And that is a key focus of this. In fact, under the authorizations, the it specifically says that you shall review the goals, but it also says, you shall, and PPB is responsible for trying to coordinate the timing of their review to make sure that you have the opportunity to coordinate your review of the plans and your community engagement around the policies, which are called directives by PPB, with the police bureau's own two-stage universal review and kind of public airing of their proposed changes to the policy. So there's a obligation by the city to help coordinate with that and make that an effective process. And I think that's a really powerful thing. You are authorized to share information to the community on these PPB, the police bureau directives, solicit feedbacks, make recommendations, and you can even request off-schedule review of directives that aren't related to the police bureau. So then finally, the third major bucket of work is the community engagement. I think Jared went through that fairly well. And of course, community engaged policing is in the name of the group. And there are specific obligations about soliciting information from the community and the police bureau about their performance, making that conversation public, being able to ask questions, speak truth to power, if you will, gather information both in your own in your own interactions in your communities and in the formal public meetings about community priorities and grievances and their sense about the police bureau's performance, and then to bring that all and advise the chief and the police commissioner on strategies and to improve the community engagement and community relations and to respond to the outcry or the interests of the public. That's a huge piece of your work, and that kind of two-way communication is critical. Some of these, obviously, there's also, I think some of you who are around in this during the summer saw another one. The police bureau has to put forward an annual report, and part of the process is that they have to share that annual report before they release it to the public with PCCEP to get your comments, and they do that. They're also they have to collect demographic data for each precinct to inform kind of engagement around in each of those precincts, and that has to be provided to PCCEP. So there are a lot of things, obligations of the city to share information with PCCEP and to share training with PCCEP, and that all feeds into what's on your schedule. So you've got to see that sometimes things pop up on your schedule because they are a requirement or they're baked into the settlement agreement or the PCCEP plan. And sometimes but more and more as we get through some of these things and we hit a rhythm with the, for example, the COCO reports being quarterly, we'll figure out how to kind of work this all in and really let you spend most of your time tackling other things. Right now, we've got a heavy load of training that's required. I think that's about it, but there's, I would also say, some of you have had conversations on the chat about, subcommittees and how many subcommittees and how, and we, at the last meeting, apparently, I'm sorry I could not attend, but there was some conversation about, well, what provisions of public meetings law do we really want to follow, and what which ones are serving us well and when might we want to meet in private. There is a provision that you can meet in private for certain very specific things. So I think a lot of that is left to your own direction, and a lot of that is governed by the bylaws, which I understand you'll be reviewing shortly. And we can have a good conversation about some of those organizational things. There's not that many that are dictated by the law or the settlement agreement and plan. It's more about what works best for you all in supporting your substantive work on these, 3 key areas. So, I'm trying to help as much as I can to get the city into compliance with the settlement agreement, and that includes PCCEP and living up to our obligation to properly support you. But once we get the machinery up and running, I'm really hoping that you all can kind of set your own agenda and really, look at the things you're authorized to do and figure out your priorities and just charge forward. So the PCCEP plan, as Jared said, section 9 of the settlement agreement is related to community engagement. And so that has some things about, the city and PPB's obligations in terms of community engagement. And then I've mentioned, I think, most of the key requirements of PCCEP in there. And then the PCCEP plan, which is much more easily adopted, is, Dory has shared that, I think, in the chat, but it fleshes out a lot more of the more specific obligations, goals, authorizations. And I went through the plan, which the one that's in effect now, and there are several different parts. I find it a little bit confusing because some of the information about what you're expected to do is in the goals, some of it's in the scope of work, and some of it is in member responsibilities, which I think is probably more the PCCEP as a group's responsibilities than individual members' responsibilities. When we we worked with PCCEP and then ran it by the amici to propose revisions to the plan, which, as Jared mentioned, they're now considering at DOJ. We tried to organize it a little bit more clearly, put numbering and so that you could refer to section 2.A, and to try to kind of really focus and make much more clear what the expectations were all along. The goal was not to substantively change the duties and obligations so much. There was some streamlining and refinement of the membership section and a few other more minor things, but there is, but it was not intended to substantively change the work that PCCEP does. There is a, yes, I believe that we have shared a, Celeste asks, is there a draft version, i.e. redlined? And I believe that we did share that earlier in the summer, but we have a lot of new members, and I think that we can certainly send the various versions out. All right. And we've got more comments. Okay.
Okay. Does that cover it for you, Sarah, for this section?
Yes, I think so. I think that we're good. So if anyone has questions, and
yeah, so I think that takes us to our kind of general Q&A section for the whole training. So we can just open it up, and if anybody wants to refer back to a slide, if that would be helpful, however this time would be most helpful for you, let us know. But we will ask that, just like in our full committee meetings, you please raise your hands, and then we will work through everybody, and also just follow all of our community agreements, and keep your individual comments to under 2 minutes, but you can also speak multiple times. Okay, I see Zainab with the first hand. Go ahead, Zainab.
Thank you, and not to preoccupy the time from everyone, and it's good to see that this is happening for PCCEP members, especially those who have never gone through the training, so I can tell the difference between when I went through the training and now, who was involved. Okay, so I'll just go there. And I don't want to take up too much time, but this is a question that came to my mind as all of you were talking and sharing. And one of the things I shared up front was that, PCCEP hasn't been the same since we had the, we call that, what was that called again? I don't want to give the term, so you can tell me what happened with PCCEP. Whatever that term that we're using right now. But it hasn't been the same. And it hasn't been the same because I came into this space where I saw community more empowered to write recommendations, more empowered to really speak up, bring people involved, get people involved, get the energy out there, get people talking about, policing and constitutional policing. And so I do struggle. I struggle with this new space. However, with that said, I do like organization. I do like functionality. I do believe that the city has not been functioning well. And if that's internal, I do believe that is. And so I will say this to say, Sarah Ames, thank you. Thank you, Jared. I listen all the time, but I also get confused based on what was happening before and what's happening now. But I will always speak to change, and change is good. So the question I have for all the attorneys out there, because this is what I've been contemplating, can you please share the legal definition of conflict of interest? Thank you.
The definition of conflict of interest in the professional rules of professional conduct let me look them up and I'll get right back to you. I mean, I don't want to misquote them. Can I get back to you and let someone else start a question, or?
There's more than you, Sarah Ames. I'm sorry just to say that there's more than you on the line here. I feel like PCCEP became very heavy in attorneys. I saw that happening. It was pointed out to me and by other members that is becoming very heavy with attorneys. And so I want to make sure that we have those who are attorneys who are here present. If you can give that definition, that would be great. Thank you.
I'll try to jump in, Zainab. It's a fair question. There is a provision of the settlement agreement that requires PCCEP members not to have a conflict of interest with the city. And that is, could exist if, for example, you are an employee of the city. You cannot be a member of PCCEP. That might be a conflict of interest. It's really a situation when, the aims of two different entities are incompatible or potentially incompatible. A conflict of interest can exist potentially or actually. I represent the United States and I represent the public interest, but that I could not also represent the AMAC, even though the AMAC represents the public interest and their membership and the goals of constitutional policing. So lawyers have a duty of care and candor to represent their client. And so, in the legal context, I can't represent another party that might have a conflict with the United States. In fact, I just joined the board of directors, or I'm now the speech and debate coach for Park Rose High School, and I had to sign a conflict of interest statement that, the federal government had to make sure that my role as a debate coach wouldn't come into conflict with my role as an attorney representing the United States. And if it does, I have to disclose right away and recuse myself. And I think that's We've had that issue obtained here in PCEP when I believe there was a recommendation where Lakiana, might have received some benefit as a recipient of, community engagement dollars or something for his organization. He had to disclose that he was the executive director of Word is Bond, and they had some arrangement, and he had to not take a vote on that issue. So conflicts don't necessarily, aren't necessarily the death knell of participation, but they do need to be disclosed and understood. And sometimes you can't, have a vote. I don't know what your question relates to, Zainab, if you have a specific concern about a member being conflicted or a lawyer being conflicted or some other conflict. For example, I can have conflicts by my spouse. If my spouse was involved with a company that was under investigation by the federal government, that could create a conflict for me, and in which case I couldn't sit in on meetings where that case is discussed, et cetera. So, boards often have that issue come up. Being a member of a board of directors, you have to, you have a duty of care and loyalty to your organization. And so if a conflict arises, you can't participate in the deliberation of that matter. It's kind of a fuzzy concept. I don't know if you have something specific in mind, but that's the best I can do on the fly here. Sarah had the right instinct of let me look it up, but I thought I would just spout off because it's a fair question. I just don't know what you mean by it.
No,
Yeah.
Sheriff Fair, did you want to? Okay.
Oh, yeah, no, I didn't. I mean, I'm not going to read the, I didn't call it up yet. I'm sorry, but I'm basically, it means that you cannot represent two clients who are opposed to each other. So if the legal interest of one client is opposed to the legal interest of another, then you cannot represent both of them. And there are times, there's also very strict rules about confidentiality of client information. And so I know within the city attorney's office, sometimes, people are representing working with individual commissioners' offices and crafting legislation, the charter amendment to create the community oversight board or something. And we learn things about one commissioner and we don't go and tell every other commissioner, or if I, am advising, if, one part of the office is advising the police bureau on how to, reform their practices, they might not tell me information that they glean that would, there's some sort of, there's a bit of kind of trying to keep good faith with the client that we are serving as the constituents of the city.
Yeah.
And
Okay.
so,
Thank you. I thank you both.
Yeah.
And I didn't realize it was going to take that long. People's time. But I will just share that when I was listening to this training, I thought about a conflict of interest in many ways, especially between how Sarah Ames, you shared that you hold up the city, but also because the settlement agreement was with the city, and then you're also setting up for PCCEP. And so when it came down to what happened, well, we're not going to name what happened with PCCEP when we were really working, even the 7 of us were working hard to ensure that the work was continuing on. It stopped us. And it stopped us in a place where we were so fired up that it kind of dimmed a lot of the light that was happening. Now, again, I like that we're not as much in conflict, because I felt like it was also the duty of the city to help us through conflict, especially in these departments and divisions that they said were part of conflict resolution, and we didn't get that. And so I would say this, that hopefully as we were moving on in this direction, and those who are new to this process, you pay attention to what's happening right now, you ask a lot of questions, and you really go do your own research. Thank you.
And I am glad that Zainab is bringing some of this up. PCCEP is in a new division. The Community Safety Division is an entity that is separate from the mayor's office and from the city attorney's office. And so, to the extent that we are still a part of the city, me as Community Safety Division staff and my support staff, and of course, yes, separate from PPB. So again, to the extent that we are a part of the city, you know, my goal as PCCEP staff is to do the best that I possibly can as your support to help PCCEP operate independently. And so, you know, it's not wrong to identify all of the very complicated forces at play with PCCEP. And I hope that in this training, you know, at the very least, we can name some of them. I think that's really helpful as we move forward, and we can identify what are these things. And you can make your own independent assessments about what you think of them and the way you want to engage as an independent community member. But it just may be helpful for you to know that PCCEP is in a different division than anybody who did present tonight. And so I will do my best to support you with the administrative functions that I am tasked with. So anyways, I want to move on to our next commenter, Gloria. So Gloria, I will hand it to you.
Thank you, Dory. My question was for Jared, and I asked him this in a chat, but I need to bring it before everyone because I'm still curious about what's happening with the court-appointed monitor. Was there one appointed, or are they still going to get one, or where are we on that now?
Thanks, Gloria. It's a great question. It is timely for this since we talked about the settlement agreement and the scope and the, you know, who assesses compliance and that sort of thing, and the potential, you know, timely conflict. I know that word has been thrown around with respect to DOJ being both the assessor or arbiter of compliance and also the enforcer of non-compliance. That could be perceived as a conflict, if not create an actual conflict, although it's by agreement here that setup maintains. The Department of Justice is, you know, exploring the idea of a court-appointed monitor with the city. The city has asked us to explore that further with them, and we are, you know, collaborating with the hope that we can reach consensus. That's where we're at, and it is you know, discussions are ongoing. They've been ongoing for some time now, and I think, you know, if there is consensus amongst the parties, it's a relatively easy switch. It will require an amendment to the settlement agreement. A lot of provisions of Section 10 would need to change. And that would require, you know, the court to hold a hearing. We know the court is in favor of it, and, you know, I guess I say no, but it's reading between the lines. It's been pretty obvious, and I think we also know that both amicus groups, the MHA and the MAC, have also put in their briefs that they are interested in shifting to a court monitor situation, and, you know, the parties are discussing that in good faith. You know, it does present a host of issues, and we're going to continue discussing those. I hope to have more to share with you all in the community at the November 9th hearing. The parties do have a mediation scheduled for October 25th. It's a confidential mediation, but, you know, hopefully we'll, you know, make progress on the things we're talking about and be able to provide an update to the court and the public at that time. We are hoping to reach consensus with the city on whatever arrangement we have going forward.
Good, thank you, Jared. For the new people who are not aware of what I'm talking about, can you just give them a brief update?
Yeah, so in all of our cases, the Department of Justice, when we have police reform, consent decrees, or settlement agreements, there is an independent court agent called the monitor, who is the assessor of the city's compliance, and they produce reports, they meet with the public, they present to the public, a lot like what the community officer, community liaison, the COCL, and Dr. Rosenbaum does now. In most of our cases, they do it on a 6-month cycle, not a quarterly cycle. Here we have the COCL doing their assessments on a quarterly basis. They were selected by the city without input by the Department of Justice. And we have the Department of Justice doing our assessments on an annual basis and there's some inefficiencies to that. And there's also, you know, we disagree on some things. You know, sometimes The COCL has found yellow partial compliance where DOJ has found green substantial compliance, and vice versa. And that can be really frustrating for the city, I imagine. I'm not the city and I don't want to speak for them, but you can imagine how that would be extremely frustrating to get conflicting views by your contracted for experts to do this work, and then the entity that you agreed is going to be the arbiter of compliance. That they can be left kind of like, well, what do we do? Like, and we also report on different cycles, and we have different experts that help us with the technical things. So that there's some inefficiencies to that. So there's some frustration to that. And in most of our cases, it's not like that. There's a court monitor who decides whether the city is in compliance or not, and speaks with a single voice to give technical assistance and guidance, and not two voices or more. So that's, I think, one of the animating reasons for why there might be some value to shifting our arrangement, and whether it's like shifting the COCL to be a monitor or finding a new independent monitor. There's a lot of permutations for how it could look, but that is the normal way that these cases are done. Here, it's different. It's the Portland way to be different. So we have a settlement agreement that is different in a lot of ways. This is just one of them. So, the court monitor, I think, there's some efficiencies, but there's some costs too. Court monitors tend to be more expensive than, DOJ is working for free, and the COCL, does a lot of work for, across the country. They are a bargain, and I don't mean that in any pejorative sense. That is just, they have agreed to do their work for less. So I hope that answers your question, Gloria, and everyone else understands. It's a topic.
I would just say that in the beginning, I mean, when we started this whole process, you heard 2012 and all that, the city had joined some of the community groups in asking for the review, and there was a very collaborative effort from the beginning. And the community, the city, I think, really was interested in this more kind of partnership settlement agreement, and not having an outside court-appointed monitor, as had been the case in some of the other cities. So we entered a settlement agreement. We don't have a consent decree. We have a COCL, a community goodness, I'm tongue-tied. A compliance officer and community liaison instead of a court-appointed monitor. And we've worked on this, and maybe in any relationship you get to a 7-year itch or something, but there's a little bit, and and Jared is not wrong about some of the inefficiencies. We get quarterly reports that we send out to COCL, and then we have to upload them for DOJ. In data, lots of data gets passed along, and we get lots of information requests coming in from both sides. And when we have our training reviewed, the PPB sends their training off for review, we send it both to DOJ for comments and to COCL for comments. So there's a lot, there is some inefficiency in this, but there's also some really good feedback from both sides. So it's just very, and so, yes, there's some friction, there's some tension in the relationship and between the parties, and how this is working, and it's taking longer than I think anybody anticipated at the beginning. And so I think it's natural to do some reassessment of what is the best way to get us to our mutual goals, which is, to have constitutional policing, and to really better have policing that serves our community, to comply with all the terms of the settlement agreement, which should help get us towards that big goal, and to return the leadership of our police bureau to the civilian elected officials of the city. I think I've heard the city attorney say that many times. And so there's a lot of different paths that we could take to get to that ultimate goal. One is to make our current situation kind of smooth out some of the friction, and to kind of think about assessing how this current system is working with the COCL. And the other is to look at an independent monitor, and whether that might be a different option. And the city is committed to exploring that with DOJ, as Jared said. I think one of the key, questions is, how do we keep the current system going and working while, at the same time, it looks like it could take a little while to both reach an agreement, get it through the fairness hearing process, get the court approval, and get that all done to have an independent monitor on terms that the city and DOJ can agree to, and that the amici and PPA have weighed in on, and the community weighs in on. I mean, that's a process. And then to get somebody hired in, this is a critical position, you want to make sure you contract with the right person, or the right person is in charge leading the team. They're almost always teams of people, which is why they ring up the bills. And then, and then it would be, a year of monitoring before we get a report, or 6 months perhaps, and then, another 6 months. But as Jared mentioned, so it's just like, how do we keep moving and improving even as we look at the independent monitor, which we might not get a report for 3 years, or 2.5 years if it's a 6-month report. So it's, there's a lot of pros and cons to be weighed, a lot of different ways to get to the goal that we share. And so the city's open to exploring those.
Great. Leslie?
Yeah, this is all really interesting. I'm one of the new members. I think been around for like less than a month. So I have a lot of questions about like, what we're allowed to do. I like that language of like what you can do. So I have a question that this has been a question since I joined, because I personally don't feel like I can just like make decisions on my own or speak for everyone. But a lot of what you were saying is like, it sounds like we can solicit feedback from like the community. I can do that. I can definitely, do that personally, but can PCCEP, for example, hold listening sessions or town halls, or is that like within the capacity of PCCEP to do, or is that more of a recommendation that we would have to make before that gets, I guess that I'm trying to understand.
You absolutely have authority, and it's written in that we have to support you in your community engagement work. And so if that's, if you want to hold specific listening sessions in different parts of the city, or, just different ways of approaching that, that would be absolutely terrific.
Yeah, I can speak to that too, Leslie. And I think that came up a little bit throughout this training and talking about those content areas that PCCEP, that are named in PCCEP's work. And community engagement is a big one, huge one for us. And so again, we are going to be thinking about ways we can kind of restructure our work. We have a meeting coming up on that. But yeah, as far as special events go, that is absolutely something that, as staff, that is one of my primary roles, is to support members and thinking about, the things that you all want to do. We are, I think, as many people have identified, we are in this tricky transition time right now because we have so much we have to get done and just like power through these like next few months. And so once we get through training and, appointing leadership, selecting leadership and all of this kind of stuff, we're going to have a lot of room for you all to come in and think about the ways that you want to do that sort of engagement, the content that you want to focus on, and that's going to happen in subcommittees and, and in other community engagement type events and all of that important stuff. But yeah, that's should be a huge part of PCCEP's work.
Yeah, because I know we do have the one in October, but that I didn't understand if that was just like mandated, a one-off, or if we could continuously do them and hold them, because as we learned in like the stops report and stuff like that, certain communities are going to have a different engagement with, so having them even in different languages or things like that, like what's within our capacity, because I know that all takes budget and that all takes time, and I don't know how much how all that works yet.
Yeah, and again, that is one of my primary functions as staff, is to support the way that members want to, the direction members want to go in with things like that, like community engagement events, and then we figure out those other pieces. But it starts with, the things like that you all identify, and we will truly have space to do that very soon. I know it may not feel like it at this moment in time, but we're kind of focused on compliance, getting members and staff up to speed, and then we're gonna, hit the ground running real soon. Yeah.
Thanks. I really appreciate that. And I know as a new member, like, I know that a lot of these trainings may be kind of redundant for like existing members. So I appreciate you bearing with the newbies and kind of allowing us the time to get onboarded.
We are all so glad to have new members here. The energy that you bring, and you are so critical to helping us do our work. So I think I speak for everybody when I say we are so glad to have all of you. So okay, next we can go to
Okay. One of my questions was about the parties involved in PCCEP work. PPB wasn't listed in the list. And I didn't know if that was because we're working to improve the PPB, but in the behavioral health subcommittees meetings that we've been having, I feel like PPB is always there. And Jared talked about PPB being very involved, but would they be listed in the PCCEP parties or a partner, or are they separate?
So
guess
there,
Confusing.
so the PPB is under the umbrella of the city. I mean, the PPB
Okay,
is the
yeah.
bureau that's the subject of the settlement agreement, but
Mhm.
that's all under the umbrella of the city. And so they are a party because they're part of the city and the subject, if that makes sense.
Yeah.
But the city is the larger party that includes the PPB.
Okay. That's what I was thinking, but thank you.
And I'll just add something, because the COAB structure, and I do see Jimmy Johnson, or he was here, and he was a long member of COAB. The COAB structure had 5 police liaisons on the board. They didn't vote, but they were there to provide insight. And that had some mixed reviews. Some folks did not appreciate that they were members, but like you said, Tia, I think it's really fantastic that they have been so supportive. The behavioral health unit and other ECIT officers have come to that subcommittee to provide input. And anytime you make a recommendation about policing, I mean, we certainly want you to be a conduit to the community and hear all the community concerns. But I think in order for that recommendation, whether it's the policy or practice or community engagement plan, it would really be helpful to understand the Bureau's perspective. And they have a great Office of Community Engagement. I don't know if that's called something else now, but Sergeant Hansberger is a fantastic resource. She has presented to PCCEP when they were constructing the community engagement plan. And I would encourage you to liaise with Sergeant Hansberger and anyone. Chief Lavelle was the captain of that division, and it was a great supporter of PCCEP at the time. I don't know if any of the members are go back that far, but now he's the chief, and so there's a long history of the Bureau being supportive of this group.
all right, Celeste.
Hey, thanks everyone. I have a couple of questions, but I'll try to condense them. And I guess the gist of the questions are for us to understand how the different structures of declaring compliance are working together. So you have the COCO, and then you have what you were saying, Jared, in terms of your resources and how there were inefficiencies and sometimes what could be an adversarial positioning, deliberate or accidental. And so I wanted to find out if we're going to have a little bit of a workshop or training or explanation on how this structure, this dynamic is affecting the ability of the settlement agreement evaluation to move forward. I mean, the fact, for example, like you said, sometimes there's partial compliance and somebody else will assess it as full compliance or no compliance, that could be confusing to us as members, because if we're trying to draw data to make some assessments from our perspective, and with the duties tasked to us as to how effective this is, it's kind of like, you know, the dueling banjos. And so I'm just wondering, will we have some kind of discussion like this where we review these challenges and barriers in this whole setup, the evaluation setup, so that we can understand? Because one of the things community members have asked me with regard to this is, how can you be in partial compliance? And that's the kind of concerns that I feel the public feels we're obfuscating about. You know, and then I have to say, well, you know, I'm not really sure too, which is why I asked the question earlier. And thank you for the explanation. But there's still some confusion on my part. Well, if it's not total compliance, if partial compliance, how long are we going to be in this liminal state? You know, this is limbo. It's kind of like being kind of pregnant. And so I really want that to be a next step we take, so that we can figure out what is the PCCEP role in cutting through this confusion.
Yeah, it's a fantastic point, Celeste. You know, I do want to emphasize that the compliance officer and DOJ are mostly in lockstep. I mean, I think there were 10 paragraphs where we had different ratings in the last, you know, assessment, but there's also a time gap. But as far as your question about how can we talk about this or unwrap it, you know, I think a subcommittee meeting is a perfect opportunity, you know, and if Zainab's settlement agreement committee were running, I would suggest that, you know, probably more convenient than taking up a full meeting if you wanted to have an ad hoc. It's important to talk about. And, you know, your suggestion or your question about what's PCCEP supposed to do to unravel it. Well, I think you asked questions of Dr. Rosenbaum and his team during their meetings. Historically, every time the Department of Justice has issued a report, PCCEP has had us come and present, and you can ask us questions, dive in to the differences or the similarities and what does it mean. The point about being kind of pregnant, partial compliance versus non-compliance is really, I think, a factor of whether, you know, from my perspective, the city has a plan to address the concerns that we've identified and a willingness to address them. Non-compliance and enforcement action is a big deal for us. We don't take that lightly. We did it in 2021 based on the protest response. I don't know if that was our first choice, you know, but there was some, you know, we were in a conflict position, and, you know, we felt that we had no other choice to represent the public interest in achieving the goals of the settlement agreement at that time. You know, here we found some, you know, partial compliance with PCCEP, where you might read it as technical non-compliance, but, you know, is when we brought those concerns to the city, Sarah and Stephanie, and to their credit, you know, they gave us a plan with some, you know, real objective metrics to get things back on track, to hire the staff that was needed. And so, you know, that we don't run to court every time. We are in a collaborative relationship. I wouldn't call us opposing counsel. We're counsel to parties to a settlement agreement that we're trying to make it work. So really the non-compliance is when there's an intractable difference that we can't resolve. Partial compliance means there's some work left to be done, but if they're on the right track, they're making efforts. Dr. Rosenbaum might have a different view of how he sees green, yellow, red. You know, I don't want to speak for the COCO. What I pasted in the chat was the Department of Justice's view of what green, yellow, red, partial, non-substantial means. So, you know, I would encourage you to you ask us questions. You guys can call us to your meeting and put us on our proofs and ask us about it. That's the best I could give you, and hopefully that'll clear things up.
Good. That helps a lot for the first question. And so I guess the next step for us then would be to figure out when we can meet and get that kind of information. And Doria, I'm at your service for trying to help set that up. My next question would be in terms, well, actually, let me kind of back up a little bit. There was an interesting question here, and I think that was Leslie that asked it about the budget for things. Do we have a point where we examine where the budget is for implementing the settlement agreement and look at the elements that the budget either provides for or hasn't provided for, and then evaluate how close we are to getting those things done? And because I wasn't sure, I know most of the efforts I've worked in with the city, and especially when you are trying to affect change, they do have a budget tied to them. And usually the budget is tied to your strategic plan. So I'm just curious. And again, that's a question that I have had members of the public bug me with. And so I'm trying to be true to my charge and bringing that question forward. And that's it for me. Thanks.
I can respond to that, Celeste. So, you know, PCCEP, my role as staff, again, is to help members fulfill the duties that you are charged with under the settlement and the PCCEP plan. If, you know, if there are things you want to do and staff is coming back and saying, we can't support you in doing that, then I think there is a conversation to be had. But, you know, budget is purely a staff responsibility. And so that is also part of my role in making sure that, you know, we are supporting you on that level as well. So, you know, that is something that staff handles and manages exclusively. But, you know, again, it is part of my role to make sure I'm advocating for the resources necessary to support you as members in having the events and doing the work that you are tasked with doing. And so, yeah, I think, you know, we're not quite at that point yet in doing those things. And so my hope is that that won't be a problem. But, you know, yeah, so we can evaluate that down the line. And Zainab.
Leslie, I'm sorry, you can go. Leslie, you can go. Thanks.
Okay, if you're sure.
Are you sure? Yeah, great, okay. This was just a question that I had because I got a little confused. There's a lot of information, so I apologize if this was explained. Are we subject to the public meetings or not? Because I just was not super duper clear on that.
I'm gonna jump in again quickly here before you know, maybe getting input from others, because I fully understand how confusing this is for current members. At the moment, PCCEP is observing public meetings law as a provision of our bylaws. Historically, PCCEP has always done this. And as Jared noted, COAB also did, but COAB interacted with it in a different way. PCCEP has done it optionally, and there are a lot of reasons for that, which, you know, I'm happy to talk with members about, you know, what we can go into depth about, you know, like the provisions of public meetings law, the ways, you know, that PCCEP could engage with them differently. We are having a bylaws conversation next week. But currently, yes, we do observe them. We are not legally obligated to observe them. That is the short answer. And I believe Jared might jump in here as well, but he might just say the same thing.
I would say exactly what Dory said. You know, I think that, you know, you guys have made the choice to observe the public meetings law. I don't know that anyone could enforce your bylaws if you breach them. That might be a better question for Sarah.
So I have to interject, and we don't have much time. I don't believe it happened quite like that. So I don't like when people, when you're going to talk about history and talk about what's happened, let's not change it. Okay, those were added to our bylaws, and I know when they were added because they weren't there when I joined. Okay, and I joined in November 2020. All right, and so I don't want to hold up this whole conversation, but great question, Leslie. Thank you for. I think that needs to be really clarified. Sarah, I have a challenge. I always have a challenge with this because I hear it in different ways. It was very, Dory, before you, the person before you was very staunch at making sure that we follow these laws, or these rules, but I feel like it's been inconsistent over the time, and I'm hoping that that changes as we look to this new process. So thank you, and everyone have a good night.
Yes, and apologies, I was referring to the last couple of years, but Zainab has been on this committee for a long time. Okay.
I would just want to put a pin in this conversation about the public meetings law and different provisions of open meetings that that PCCEP in the past has chosen to follow, because it is a great conversation for the bylaws, and I hope that we can clarify some of the confusion about what is and isn't allowed and how the law affects your meetings, and really straighten that out and make it much more clear in the bylaws when we have that conversation.
Yes.
Okay, I think that is all we have for questions. So as we've been talking about, I'm gonna quickly share my screen again. We have some meetings coming up. Sorry, everyone. Okay. So as we've been discussing, we have a very important meeting next week on bylaws and subcommittees. I hope that all of you will be able to attend that one. Very critical that we have that quorum and be able to have that discussion about these important changes that are coming up. The following week, we have our town hall with Independent Monitor LLC on the response to the 2020 protests. And then October 19th is going to be another very important meeting where we will be holding or selecting our co-chairs. And so, after doing the business of discussing bylaws and subcommittees, that will take us into, this co-chair meeting on the 19th. Then we have another training and the status conference after that. And that concludes this meeting. Thank you to everyone for attending tonight. I very much appreciate your time and for learning a little bit about PCCEP's history and kind of where we are today, and looking forward to the work that we have ahead. And I especially thank our continuing members who may have done this training in the past and doing a little refresher with us. And that will conclude tonight's meeting.
Sorry, Dory, you have a comment in the chat that I'm not sure if this was brought to PCCEP's attention, but it looks like it was brought to someone's attention.
Okay, and I will have to discuss that with that community member offline. And again, I thank you all for attending tonight, and this concludes tonight's public meeting.